On this week's episode of the podcast, I'll do it myself.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and I have a topic for you this week about small claims court. Now, before I get there real quick, I do want to welcome everybody to 2022. I know by the time you're listening to this, if you listen to it on the day of release, you've already been wished a Happy New Year a whole bunch of times, but I want to add my hopes for a happy and prosperous New Year 2022. And if you're listening to this beyond the date of release, then I hope you have a happy New Year and a prosperous New Year in whatever year you happen to be listening to this episode. Speaking of New Year, I do want to say Happy New Year to our sponsor, Sam Cohen with Attorneys First Insurance. As you longtime listeners know, Sam provides errors and omissions or professional liability insurance, basically malpractice insurance, to attorneys and title companies all over the country. Now, he has a specific focus on Florida and Texas, but Sam can write malpractice insurance or errors and omissions coverage or E&O insurance for attorneys and title companies anywhere in the country. So a great referral for Sam and a great way to support the Crushing Debt Podcast is to refer a title company or an attorney that you know to Sam to quote his E&O policy, to quote their malpractice renewal. Now, Sam's not a hard salesman. Sam's not going to ever make you look bad. Sam is just going to be honest and tell the attorney or title company whether he can comparatively shop the quote or if the existing coverage the attorney or title company has is sufficient. So please reach out to Sam. It's sam@attorneysfirst.com, or you can visit their website, which is also attorneysfirst.com. I know you can also find them all over social media on Facebook and other social media outlets. So thank you and Happy New Year to our sponsor, Sam Cohen. The title of today's episode, actually, I sort of thought about in terms of a Marvel movie. At the end of the first Avengers movie, where Thanos grabs the Infinity Gauntlet without any of the Infinity Stones in it and says, "Fine, I'll do it myself." And today's topic is really a topic about small claims court. Now, I did an episode about small claims court way back, episode 7 of the show. So the first, month or two of the show, I did an episode about small claims court. I'm going to expand on that a little bit in today's episode. That episode 7 was really only, about 8 minutes long. So I'll expand on it a little bit today in today's episode and talk about it. But before I get there, I want you to imagine sitting in a courtroom, and you've got the wood railings with the swinging wood doors, and then beyond that, you've got the plaintiff's desk on the left and the defendant's desk on the right, or maybe it's reversed. You've got maybe people sitting at those desks. You've got a podium there in the center, and then there's the judge's seat, and someone is sitting up there in a robe or in a suit or in a something, and attorneys are bustling back and forth, and people are coming in and out of the room. And there's, in the galley, behind that wood fence, behind that wood railing, there are a ton of people sitting there, maybe 20, 25, 30, 40, 50 people all sitting there. And the judge will take the bench, and the judge will say, "Welcome to everybody who's here for hearings today. You are all in small claims court." And the judge will start to explain the process. The reason I wanted to go through that is that it seems a little bit intimidating to be sitting in that scenario if you've never been in a courtroom before. It can be very, very intimidating to sit there. Now, especially in today's times of COVID, we don't do hearings in person anymore, and we hopefully will get back to that one day. But at least for now, everything's on Zoom. So now, instead of the wood railings and the two tables for the plaintiff and the defendant and the gallery of mediators and the gallery of people waiting for their case to be called and the bench with the judge, instead of any of that stuff, you're all on Brady Bunch tiles on Zoom, and the judge will go through the cases one by one. Now, a couple of things about small claims court. It is actually designed to be used without attorneys. So people are represented by attorneys, and a lot of plaintiffs that bring cases in small claims court are represented by attorneys. Typically, companies that are pursuing credit card debts, a lot of them are represented by attorneys. But it's really designed for the parties to resolve their issues without really getting attorneys involved. One other thing about small claims court is that the rules of civil procedure are a little bit relaxed because of that reason, because the judges know that people that walk into court unrepresented really aren't going to be very familiar with all the rules. I mean, think back to My Cousin Vinny, where the judge hands Joe Pesci's character this big, thick book and says, learn that. Well, what he was handing him was the Alabama rules of criminal procedure, and he expected Vinny to know all the rules of Alabama criminal procedure. Now, there's a different set of rules when you're in civil court. When you're not in criminal court, there's a slightly different set of rules, civil procedure. And so judges know that not all people that walk into court are going to be familiar with civil procedure, and so the rules are slightly relaxed. Now, at the end of the day, the judge does have to follow Florida law. The judge does have to follow Florida civil procedure rules. But in my experience, those rules can be relaxed. Small claims court is also for people that are owed $8,000 or less. So if the amount in controversy is $8,000 or less, you'll be in small claims court. Now, when I recorded episode 7, which I can see was in December of 2015, was when it was released, at the time in episode 7, the limit was $5,000. Now, that limit was raised, I want to say about 2 years ago, as I record this, to $8,000. So now small claims court is for any dispute $8,000 or less, not including costs and attorney's fees. So if you are owed $7,999, you're in small claims court. If you're owed $8,000, you're in small claims court. If you're owed $8,001, you're in county court. You're not in small claims court anymore. So you've got to understand how much is owed. Now, if you've got court costs and attorney's fees that are going to drive your ultimate award above $8,000, you can still be in small claims court as long as the principal balance that you're owed is under $8,000. And that's part of the reason why you don't get very many attorneys that are really excited about going to small claims court, because it's rare that we get an $8,000 case. Typically, some of these cases are $2,000, $4,000, $3,500, $5,000. Well, typically, my fee to defend a lawsuit is going to be $2,000 or less, especially if it's one case where we're considering a bankruptcy. You're going to be in that $2,000 range, give or take, plus or minus, filing fees and costs and whatnot. And so consider a situation where you owe the plaintiff $3,000 and you come to me and you say, I want you to defend me in this small claims court case. And I say, okay, it'll be $1,500. Well, I've already, if the plaintiff wins and gets a judgment for $3,000, now you're $4,500 into it. Even if the plaintiff says, you know what, I'll take a discount, I'll take $2,000 and we'll settle. Well, you paid me $1,500, that's $3,500. You would have been better off just paying the plaintiff the $3,000 that they wanted. And so that's why a lot of times attorneys won't take small claims cases. I mean, $1,500 would be a flat fee, and that would be for the very beginning of the case. I'll explain the procedure and how these cases progress in the court system, but if one of these cases goes to trial, you could end up paying attorney's fees in excess of the $8,000 that the plaintiff may be requesting. Definitely, if the plaintiff is requesting something like $3,000 or $4,000, you're going to go way over that in attorney's fees if you take this thing all the way to trial. And so, again, another reason why these cases are designed to be done without attorneys. And so, it's a process where not a lot of attorneys like to get involved. Now, I do have something that I'm going to talk to you all about towards the end of the episode about maybe ways to have an attorney represent you in a small claims case that would be affordable. So stay tuned for that. I'll get into that here in a few minutes. But let me talk about the process. Let me talk about the process of a small claims case. So it's filed using something called a statement of claim. That's what starts the lawsuit. Now, in a typical lawsuit, it's called a complaint. But in a small claims lawsuit, it's called a statement of claim. And the plaintiff fills it out and says why they believe they're entitled to money. Sometimes it can be, the defendant borrowed $4,000 from me and hasn't paid it back. or the defendant caused damage to my property in the amount of $3,500 and refuses to pay it back. Or whatever reason the defendant bumped my car in the parking lot and caused $1,000 worth of damage to my bumper and refuses to pay me, and insurance won't cover the damages. I mean, whatever the reason, why is the plaintiff entitled to the money here? And that's typically what the statement of claim shows, is how much is owed and why. Now, typically what happens is the court will issue a date, a hearing date, probably, I think, around 45 days, give or take, from the date that the lawsuit is filed. Now, those dates may be slightly off, especially now when we're still dealing with Zoom and court schedules and trying to get rid of backlogs and all that other stuff. But I believe the hearing date can be 45 days away. I've seen some as many as 60 or 90 days away. And the court sets a date. So the next thing that has to happen, the plaintiff has to serve the defendant with the lawsuit, either using the sheriff or a private process server, simply someone who knocks on the door. Are you Fred Smith? Yes, I am. Here's the lawsuit. You've been served, and it tells you when and where and how to appear, especially if it's going to be by Zoom. It's got all the Zoom instructions on when and where and how to appear. In fact, as I record this episode, I've got a small claims hearing later today at 2 o'clock by Zoom. And part of the reason I sort of tossed it in as a freebie because the lady's going to be filing bankruptcy with me here in a few weeks. And so I said I would go to the small claims hearing because she was nervous. So the hearing date, the initial hearing date, will have, whether it's in person, whether it's by Zoom, whether you can call in, whatever, the date, the time, all the different details. So you get to court, whether it's in person in that scene that I described at the beginning of the episode with the wood railing and the tables and the judge's bench and all that kind of stuff. You get to court, or maybe it's by Zoom. And I've seen situations where judges explain the process before they get started. And typically they go through 20, 30, 40 cases in a certain period of time. And so you may be in there with other people waiting for their cases to be called, other plaintiffs waiting for their case to be called, other defendants waiting for their case to be called. And so I've seen situations where the judge sort of goes through the ground rules. I've seen other situations where the judge just starts in. I've seen a lot of situations where it's not even a judge. It's someone called a magistrate or a hearing officer. So they are not the judge of the case. They're just there to process that initial group of cases that are in court that day. That's really the special master or special magistrate hearing officer's job, is to oversee those group of cases that are in the court that day. Now, typically what will happen is the judge will say to the defendant, do you admit or deny that you owe the debt that the plaintiff is seeking? If the defendant says, I admit that I owe the debt, bangs the gavel, judgment is entered in favor of the plaintiff in the amount that the plaintiff has requested. If the defendant says, I deny that I don't owe this debt, or maybe I owe it, but I don't think I owe what they say I owe. It's a credit card, and I haven't received a statement in 10 years. And so they're telling me I owe $6,500, but I don't think that's true because when I stopped paying, I only owed $1,500. And so I admit that I owe it, but I deny that I owe as much as they say is owed. Or I flat out deny I owe the debt. I didn't cause the damage to that guy's car. I didn't cause the damage to that lady's house. I didn't borrow money from Fred Smith. And so I'm denying that I owe the money altogether. Well, in a situation like that, where the amount of the debt or the existence of the debt is denied, there are a group of mediators, court-appointed mediators, that sit in the courtroom. And so what they'll do is they'll grab the plaintiff, they'll grab the defendant, they'll literally go to another room, and they'll mediate the dispute. Now, again, by Zoom, they'll literally go to a breakout room and mediate the dispute. Now, the role of the mediator is just that, and I've talked about mediation on other episodes of the show before. The goal of the mediator is to see if we can find a middle ground, a common ground, some kind of settlement. And if it settles, the mediator will draw up the agreement, and the case is over. Now, what could some of the settlements look like? Well, if it's a $4,000 debt, the defendant agrees to pay $2,500 at $500 a month for 5 months. Or defendant agrees to pay a lump sum. It's a $4,000 debt. The defendant agrees to pay a lump sum of $3,000 within 30 days. Or I've had them settle for as low as $25 a month, $50 a month to some reduced balance. That's typically what a settlement is going to look like. Now, again, I mentioned attorney's fees. Here's the interesting issue. In a lot of cases, attorney's fees are waived as part of the settlement. So if you're a plaintiff looking to bring one of these cases and you're owed $3,000 or $4,000, you can probably expect something in the range of $1,000 to $2,000 of attorney's fees and costs. So now you're owed the $4,000 and let's say $2,000 in attorney fees and costs, so you're in it for $6,000. If the defendant agrees to split the difference, and you agree to settle this case by splitting the difference, splitting that $4,000 in half, you're going to recover $2,000. You were owed $4,000. You've got $2,000 of attorney's fees. You're in it for $6,000. You're recovering $2,000. So for all that time, effort, and energy, you basically broke even. The $2,000 that you paid to your attorney is the $2,000 that you're going to get back. Now, a lot of people are going to say, well, why can't we include attorney's fees? Well, you can, but like I said, it's typically one of the first things that gets negotiated away. Now, let's flip it and say, okay, from a defendant's perspective, you're being sued for $4,000 and you pay me $1,500. Well, what that means is I have to get at least a $1,500 reduction to create any value for you. So if you owe $4,000, I got to get it to $2,500 just for you to break even. If I can settle it for $3,000, you're now $500 in the hole. You'd have been better off settling it on your own. So that's why a lot of times the finances have to be considered. That's why a lot of times attorneys don't like to be involved in these kinds of cases, because frankly, we just can't really create the value for you as plaintiff sometimes, and even as defendant sometimes. We just can't create the value for you because the margins there are so thin. So you go to mediation. If it settles, it's over. And that's why there's a special master or a magistrate, because a lot of these cases do end up settling right there, right then on the spot. Now, you may have to wait for a mediator to come available if your session is towards the end of the docket, the court's calendar, or you may have to come back another day if there's a lack of mediators. But typically, the next step after that first hearing is mediation. And in the majority of cases I've been involved with, the mediation happens that day, on the spot, right there. Now, what if it doesn't settle at mediation? If it doesn't settle at mediation, or if it doesn't settle at that first hearing, you go back to the hearing officer, the magistrate, and they will give you a time and a date. And it may be on the spot, it may be a few days, weeks, months later. They'll give you a date to come back in front of the judge of the case now, and present your evidence and try your case and try to explain to the judge as the plaintiff why you owe the money, and try to explain to the judge as the defendant why you don't owe the money. So you go to trial if it doesn't settle at mediation. And when it goes to trial, everything is back on the table. So you can ask for the amount that you're owed, the filing costs, the attorney's fees, assuming attorney's fees are warranted based on the type of lawsuit it is. You can ask for all that stuff, and that may be where you ultimately get it. Now, there's one other consideration here in a small claims case. Again, it's designed for amounts that are owed of $8,000 or less. And one of the things I try to promote here on the show is, making money, creating room in your budget. And I know that $8,000 is a lot of money. $8,000 is a lot of money for me. But if you can't maybe quickly come up with $8,000 or $4,000 or $2,000, the chances that the plaintiff is going to be able to recover anything from you at all are slim to none. I mean, especially here in Florida, if you're a single parent with minor kids, your wages are exempt from garnishment. If you stop paying your credit card because you became disabled and now all you're getting is disability income and Social Security, those things are exempt. So as a plaintiff, what you also have to consider is, if I get this judgment, am I going to be able to collect it from the defendant? And as a defendant, one thing you want to think of is, if I get a judgment against me, am I going to be garnished? Or, what can the plaintiff do to collect anything that I may or may not have? The lady that I'm going to the hearing later today, we're actually filing bankruptcy because she's got more than this one small claims lawsuit in terms of credit card debt. And so we're just going to file bankruptcy and blow it all out. And so we're not going to have to worry about whether she gets a judgment against her or whatever, because we're going to eliminate all the debt later with the bankruptcy. So those are some of the other considerations that, as you're figuring out what do I do in small claims court? Should I, if I'm the defendant, should I go to court and defend myself? Well, again, I'm going to say that depends. You're always able to go to court, due process. You can always go to court as a defendant and defend yourself. But again, what's the resolution here? If you don't have any money, if your assets are exempt from garnishment, if your wages are exempt from garnishment, why spend the time to go to court? I mean, yeah, they'll get a judgment against you. Yeah, it'll impact your credit. But if this is a credit card debt, your credit's already taken a beating. You might as well just get the judgment, use a bankruptcy, use some other settlement, eliminate the debt, and be done with it. Why spend the time, effort, and energy? If you're a plaintiff, what am I ultimately going to be able to recover? What would I like to recover? What do I think I can recover? And use those. I know it's a very emotional thing to sue somebody or to get sued by somebody. And that's, I've said before on the show, one of the advantages, I think, of having an attorney is we get to take a lot of the emotion out of the equation, and we get to look at it in terms of dollars and cents and what can you recover, what should you be able to recover, what's your exposure, and we can look at it from that angle and actually counsel you. I really didn't understand until I was done with law school why attorneys are also called counselors. We can counsel you on what the best method is, what the best strategy is, what the best avenue is. So that's basically small claims court in a nutshell. Again, the statement of claim, it gets served with a hearing date. You go to the hearing, I admit or deny that I owe the debt. If I deny that I owe the debt, we go to mediation. If the mediation doesn't result in a settlement, we go to trial. Now, one of the other things that I've done a lot in small claims court is I've been able to contact the attorney if the defendant comes to me right when they get served with the lawsuit, like within a few days of being served with the lawsuit, or at least maybe we're a couple of weeks out from the hearing date. Even if it's not right after being served with the lawsuit, we still have a couple of weeks pending before that hearing date comes up. I can call the bank's attorney and I can negotiate with the bank's attorney, with the plaintiff's attorney. I can negotiate a settlement. And if they say yes, nobody has to go to the hearing. The plaintiff doesn't have to go. Defendant doesn't have to go. I don't have to go. Plaintiff's attorney doesn't have to go. Nobody has to go. We can just report to the court that the matter's been settled, and that's it. It's done. So, contacting somebody as early as you can would be a great way to try to resolve this type of situation so that you would never even have to go to court. So also keep that in the back of your mind. Now, a few minutes ago, I also talked about something that I was considering that would allow you to actually do this on your own, that would allow you to actually represent yourself. A lot of you know I've written 2 books, Crushing Debt, taken from the title of the podcast, 9 Strategies to Eliminate Financial Bullies, and then I wrote Become Debt Free in 1 hour or less. What I've been thinking is developing a course about how to represent yourself in small claims court and charging some amount of money. Nothing anywhere near what I would charge in attorney's fees. And I don't know what I would charge, maybe $100, maybe $500, maybe $50, $250. I don't know. I haven't really priced it yet. But what I was thinking is developing a course or developing some materials about if you're a defendant, how do you represent yourself in small claims court? If you're a plaintiff, how do you represent yourself in small claims court? And you would be able to buy that stuff, and so you'd still get my advice as an attorney, but you wouldn't have to pay for me to be there to represent you. Now, along with some of that, you'd get the Crushing Debt book, you'd get the Become Debt Free book, you'd get some of the other materials that I've created, all as part of that package. And so really I have 2 questions for you. So number 1, do you think that would be something of value that I should spend some time here to create? Do you think I should create a program or a course or some material on how to represent yourself in small claims court? And if you think the answer is yes, what would you pay for something like that? Would you pay $50? Would you pay $500? I mean, obviously, I don't want to get too high because then you might as well just hire an attorney and be done with it. But, how much would you pay for something like that? Would you pay $99.99? Would you pay $250? Would you pay $50? Would you pay $500? $400? $350? How much would you pay for something like that? So if you could either send me an email, sean@yesnerlaw.com, or go to the website, yesnerlaw.com, and send me a message through the website, or leave a comment wherever you're listening to today's episode, or if you found us on Facebook, leave a comment in the Facebook post, or LinkedIn, leave a comment in the LinkedIn post, or YouTube, or wherever it was you saw us today or heard us today. Let me know. Number one, would it be beneficial to create a course on how to represent yourself in small claims court? Number one. And then number two, if the answer to number one is yes, what would you pay? How much would you pay for it? And so I will take your feedback, and then I'll update you in an upcoming episode as to whether I'm going to create or develop such a creature. But I think for now, that'll do it with our first episode of 2022, our 303rd episode overall. Thank you very much for your listening. Thank you very much for all your support. Thank you to our sponsor, Sam Cohen. I hope everybody has a fantastic 2022, and I hope that at the end of the month you have more money rather than at the end of the money you have more month. That'll do it for this week's episode of the Crushing Debt Podcast, and we look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.